Welcome to Biztech's Technology Show. Today we discuss the law and its impact on how it is evolving in the face of rapid changes in the technology landscape. Now, to bring an expert lens to our conversation, we have two distinguished guests today, Danny Ong, co-founder and managing director of Setia Law, and Wern-Jhien, who is the co-founder and director at Setia Law. Setia Law is a firm based in Singapore that focuses on dispute resolution, fraud, financial crimes, restructuring and insolvency, as well as investigations. Now, to tell us more, gentlemen, welcome to the show.
Thanks for having us, Brian.
Thank you for having us, Brian. It's a privilege.
Now, for a start, perhaps we could start with you, Danny. Tell us a little bit about Setia Law and what you do.
Well, Setia, we're a team that spun off from one of the large law firms in Singapore with a primary focus on a few pillars, as you quite rightly pointed out. This commercial and financial disputes, regulatory financial crime investigations, fraud, international enforcement, and corporate distress. When I say corporate distress, that would be in lay terms, restructuring and insolvencies of corporate distress situations. The idea was to focus on these specializations and drive those specializations further and deeper with a young team of lawyers and with the ability and freedom to think out of the box. And we like to think that we are slowly establishing ourselves as leaders in this space. And a lot of our work actually involves technology, whether it's involving investigations, the latest disputes on the blockchain, digital assets frontiers, and software disputes, for example.
Okay, so Danny, then what do you specialize on? What is your key focus?
Mine, it would be anything to do with finance, right? So we typically act for financial institutions, private credit funds, hedge funds, for private equity funds that have invested into any manner of businesses, whether it's brick and mortar businesses or technology businesses. Quite often, we are brought in by the investors. We are brought in by sometimes distress advisors, as special in counsel to conduct investigations. That's what I do and the team does. Yeah.
Okay, and I'm going to come back to you a little bit later because there's a lot of things to unpack that happened perhaps in 2023 in that space that's evolving, I think, still in 2024 with particularly with venture capital and private equity. Yes. But Wern-Jhien, we're going to come over to you. What is your specialty and what do you bring to the table?
So before I started life as a lawyer, in law school, I wanted to do construction law. I come from a family of engineers, but as fate would have it, when I graduated, it was around the time when a certain investment bank failed, Lehman Brothers, and I joined this big law firm at the time, and I was paired with Danny Ong, who was then one of the lead partners on the Lehman Brothers insolvency. So I never got to practice much of construction law. I was thrown deep into finance, basically, and specifically in the context of insolvency. So the first decade or so of my practice, I did a lot of finance work, especially in disputes and contentious insolvencies. After that, in the last 4 or 5 years or so, the work I was doing started to be more focused into fintech, digital assets, blockchain, crypto, basically. So that is pretty much how I spend most of my days these days, looking at blockchain, tracing stolen digital assets across the virtual world.
Okay, so then I'm going to jump in and pick your brains a little bit, Wern-Jhien. What are some of the key trends that you've seen? Because this landscape has evolved so much just in the last 4 or 5 years. Walk us through some of the trends that you've seen and obviously some of the stuff that you've worked on and what you're seeing looking ahead in 2024.
So like I was saying, I spent many years focusing on finance-related work. And if there's any industry that has undergone dramatic transformation as a result of technological development, I must say it's in the world of finance, right? I mean, a few years ago, we've started hearing terms like fintech, and different new players started popping up. brought innovation to things like every aspect of our lives, from how we make payments, how we borrow money, how we lend money, how we bank. Every aspect of our life have been, have changed in the last 5 to 7 years. Then came the next wave, which was blockchain. Most of us would have heard of blockchain through cryptocurrencies, but it's definitely much more than just cryptocurrencies. A few years ago, we started hearing terms like NFT, digital assets, and now we're hearing terms like tokenized securities and so forth. So one of the key trends I think is especially in the world of financial securities is tokenization, basically. And so that's one. The other one is obviously much talked about AI. For example, we know that many FIs have already deployed AI in their internal systems. It allows banks or financial institutions to conduct their own due diligence, compliance checks, and so forth. But what's more interesting to us lawyers is how these firms have started adopting AI in terms of the product deliveries. So even things like financial advisory services, how we do trades, brokerages are all deploying AI into one or more facets of their systems. So yeah, I mean, I think blockchain and AI, I believe are the two key trends that we are seeing at the moment.
I would just add, Brian, that on the point that Wern-Jhien made earlier, I think tokenization in 24-25 will be likely to be quite a big focus of the industry. And when I say industry, instead of your atypical tech-focused businesses, it would actually go mainstream into the financial institution space, where FIs would actually look at how they can market and launch capital markets products in a tokenized form. And I think there will be, I mean, as it is already, regulators around different jurisdictions across the world are looking into that, developing frameworks for that and studying how that could be brought into reality. And I think 24-25 is when we actually see some sampling of that, examples of that happening in real terms, whether it's an IPO, a tokenized IPO, or it's a tokenized REIT, and so on and so forth. I think we're going to see that. I think something to keep an eye on.
So Danny, and I want to push you ahead. I think push you on that a little bit, because what this opens up is a Pandora's box around regulation. So there are some jurisdictions that perhaps, like Singapore, are a little bit ahead of the curve, but then there are a lot of jurisdictions across the region in particular that are lagging behind. How can regulators keep pace with this rapidly evolving technology landscape?
I think it's somewhat competitive as well, right? I think you've got a few jurisdictions: Hong Kong, Singapore, Dubai, and of course, last but not least, New York, London, all vying to be leaders in that market, right? In that digital assets market, what could we do? So each of them are actually studying and coming up with their own frameworks and regulatory frameworks. There may well be some level of disharmony in the first instance, but conceptually, I think underlying and underpinning all these regulatory frameworks that will eventually roll out, I think there'll be some level of consistency. And I think don't be surprised that actually when you look at it in substance and peel off the layers, a lot of it is similar or not dissimilar to how the traditional capital markets are regulated, right? It's just that the form is called a token. I mean, obviously, you would have to adapt certain rules and regulations around the manner in which things work. For example, on the blockchain, the anonymity, who's the central registrar, and things like that. So the technology aspects of it will require adaptation of the pre-existing framework. But I think you will see the baseline framework very much taking a leaf out of the old stuff. But you're quite right. I think at the same time, you will have jurisdictions which will be lagging behind. And I think that in itself creates a market dynamic, right, for fundraising, for investor interest. If London is able to establish an excellent framework that's welcoming for tokenization of capital market products to be tokenized capital market products to be launched, then that will be the destination in which issuers will want to do that fundraising exercise there. While some others lag behind. I think it will create other issues as well as a result. I mean, imagine if you bring it to another jurisdiction and that is fought over a tokenized share, and one some court somewhere in some jurisdiction will say, "What the hell is this?" So I think there will need a certain amount of time for education, for consistency and harmony. But at least in the key financial centers, I think there will be less disparity.
Okay, but gentlemen, then let me ask you a simple question around which I can't get my head around. How do you then, from a legal standpoint, take action against a decentralized autonomous organization, right? There is no, now that's a new legal structure, no central governing body, members share a common goal, but then so how do you, if they do something wrong, how do you go after them if you're a customer or a supplier or something like that?
Yeah, so when I first heard of the term DAO, right, decentralized autonomous organization, that was exactly the first question I asked. Because I'm a litigation lawyer, I need to know all the time if something goes wrong, how do I sue, who do I sue, where do I sue? But thankfully, there have been case precedents from other jurisdictions, and lawyers all over the world are starting to innovate, are starting to test a different strategy to bring action. So if you pare down all the fancy jargon, right, a decentralized autonomous organization is basically a group of people coming together for a common. In essence, it is a partnership, right?
Okay.
The real difference is that in most DAOs, they are anonymous, and instead of having a written partnership agreement that defines who gets what vote and how do we make decisions, they have a protocol. And there are the systems by which the voting takes place, how the decisions are implemented, most of which are automated, and they rely
So basically, that's your shareholder agreement.
exactly
Sure.
a partnership agreement. Because and obviously, take for example the laws of Singapore, which is not too different from Malaysia or other common law jurisdiction. We could arguably consider or treat a DAO as a partnership, and that attracts centuries old legal principles that define how partnership are regulated basically. So there are ways that we lawyers have come up with to try to bring action, but the real challenge is not the law, actually. The real challenge is practical. If you don't even know who is basically the holder of a governance token, basically the token holder who is responsible for voting and decision making, how do we even know where to sue and who to sue? In cases where claimants are lucky, they will encounter a DAO. They have some kind of centralized server or entity that has all this information, and you just go to that country and seek disclosure on this. But in a truly decentralized structure, I think it's near impossible, I would say.
Okay, so which brings me to a question, right? Another question, and either of you can answer this. If in a situation like this, where it's a decentralized autonomous organization, we've got all these laws, as you said, we treat it like a partnership. There's centuries of legal precedents around it, but then how is enforcement in different jurisdictions going to happen?
So again, it depends on the type of structure that we're dealing with. We have been involved in cases where the enforcement mechanism takes place outside the court. Basically, you have to use your ground intelligence relationships network to detect or to identify the relevant people that has the ability to make changes to a protocol, and then you negotiate, you work, you seek their cooperation and so forth. There are also instances where people effectively hack into the protocol and make changes so that it complies with whatever the court orders. The hacking, although it's called hacking, but it's a hacking that is potentially authorized by a court of law. So there are all these ways to circumvent the need to hold a person accountable. You go straight to the system, you penetrate into the system, and then you make the necessary modification to achieve the effect that's intended by a certain court order.
Okay, fascinating. Now I want to direct the conversation around really financial, the financial side of what you guys do. Danny, I think you mentioned when you introduced what Setia Law did, and one of the things that you do is you work a lot with venture capitalists and private equity folks in terms of structure, some of the financial crimes that have taken place. Walk us through some of the interesting. There are a lot of cases in 2023, not only across the region, where venture capitalists had to engage law firms like you to really work on some of their investments, for example, and perhaps some improprieties that happen in their investments. Walk us through some of the perhaps interesting things that you've observed or perhaps worked on in the past few years.
Thanks, Brian. I think one has to start and maybe perhaps look back at it from the perspective of what has happened in the last 15 years, right? I mean, you've got a situation where the private equity funds and the venture caps have raised, sitting on a huge pile of money. They're chasing after targets to deploy the money into interesting businesses, tech, biotech being the flavor of the last decade. Pumping in, valuations keep getting driven up on unprofitable businesses and representations and figures which they see from their due diligence exercise or limited due diligence exercise. And at some point in time realizing, and that's when we get involved, that actually the figures don't look quite right. That's one typical example which gets picked up. Commonly also is that there's some insider that actually whistleblow and leak the fact that there's some massaging of numbers or some diversion of monies or diversion of sales or some funny accounting exercises and manipulation of the books that's happening behind the scenes. And you would have investors represented on the boards whose board nominees are themselves nervous because they're now sitting on a board whereby they owe duties to creditors and to shareholders. And when these things have happened under their noses while they were sitting as board members. So typically, that's the scenario we get involved in. We come in, we investigate together with forensic investigators to look at the numbers, the accounts, and what bad conduct or naughty conduct can be unraveled from that exercise. And quite often, when the fish thinks it stinks. It does mean that it's a little bit rotten at least. And it's getting fairly common to see founders of certain firms, whether tech, biotech, who in their, how do you put it? I wouldn't say desperation, but in their enthusiasm to raise funds, and to achieve certain valuations and become the unicorns, actually driving numbers and driving data in a certain direction that is not quite accurate. And once you unpeel the layers, it falls like a house of cards. I think the real difficulty there is confidence and trust, right? How do you then look at restoring the business, steering the business in the right direction, changing the leadership, which is so entrenched because they're startup founders from day one. 2/3 of the people and the staff have been hired by these founders. How do you change leadership, change direction, clean up shop, and instill corporate governance practices and safeguards and manage those risks moving forward? That's one. The other aspect is actually being realistic and looking at the valuation itself as well. The valuation obviously would have plummeted by a huge amount, and without the sort of the stardom behind the startup or the tech company, then what really is left at the core of the business is questionable. So it's always very exciting because in those instances we're looking at joining the dots, filling in the gaps in terms of investigations, telling the full picture. So it's playing a bit of a role of a Sherlock Holmes, and then advising the board and the investors as to what are the recourse options, what can we do, how can we do it in a way that's sensible, that will manage the risk of a fallout in terms of managing expectations of the staff, the key individuals which are so crucial and essential to the operations, making sure that they are not disillusioned and they continue to be committed. And at the same time, quite often, how do we find new money to get in there? All in the context while then exploring, typically in these situations, the company is on the brink of insolvency. Does it help to put it into insolvency or rather in the insolvency process, like a scheme or Chapter 11? Would it be better? Would it be worse? What about the reputational loss? Is there a recovery from that? So that there is all these pieces that are going on, and typically these exercises would also typically trigger defaults or cross defaults across financing documents and with the lenders. So you've got lenders on your backs, you've got shareholders, investors on your backs, breathing down hard. And all having sort of different objectives and agenda. So it's exciting for us, not so exciting for the company, but that's what we do.
Now, gentlemen, it's been a fascinating conversation, but we've run out of time. We could probably talk for another hour. But before we leave, any final thoughts that each of you would like to leave us with? And I want to start with Wern-Jhien.
So I think maybe I'll just add on to something Danny mentioned earlier, and in response to your question. There's something quite interesting about the region that we are in, Southeast Asia, especially in the world of finance and investment, because from the fund's perspective, investors' perspective, they always treat Southeast Asia almost like a single market. It's just like how we lump emerging market almost like a unified market, right? But when it comes to distress, crisis, or enforcement, that's when most of them will realize for the first time that Southeast Asia comprise many very different countries with very different legal systems. And in crisis situation, distress situation, investors will need more often than not support from local authorities, local courts, local law enforcement, and on the ground support to protect their interests. And dealing with a crisis situation coming out from Vietnam is entirely different from a situation coming out of Indonesia or Malaysia or Thailand. So that's why as lawyers sitting in Singapore and lawyers who are lucky enough to have dealt with cases that stretches crosses boundaries in the region, it has been so fascinating to do work in this space, because every case is different. And any given one case, we will have to deal with 2 or 3 or even more systems of law. Danny?
Yeah, I think picking off where you left off, Wern-Jhien, and I think to your point, Brian, I do think that coming in 24, 25, you're going to see more distress in the private equity space and the private credit space. So much investment and lending has gone into the region. When I say region, I mean the emerging market region, including Southeast Asia. A lot of that involved structures in Singapore, in BVI, Cayman intermediary structures. I think you're going to see a lot more distress in that space. A lot of that would involve technology, biotech businesses underlying it in emerging markets, whether onshore in China, onshore in Indonesia, and so on and so forth. So there will be a lot of complex situations that will be coming up, and I think that's something to watch out for.
Danny, Wern-Jhien, thank you very much for taking your time to come on the show.
Thanks for having me, Brian. It's a true pleasure.
Now, we've been speaking to Danny Ong, co-founder and managing director of Setia Law, and Wern-Jhien, co-founder and director at Setia Law. This has been Biztech's Technology Show, and I'm Brian Fernandez. This interview will be on our website, www.biztech.asia, as well as our syndication partners, TV stations, radio stations, and websites. Thanks a lot for tuning in.